Welcome back, everybody. In tonight's legal brief, we're talking about, Carl, we're talking about the cost, of the injury, because sometimes when you have limited insurance, but you got extensive injuries, like you all were talking about the case earlier, thankfully he was okay, but when you've got some serious injuries, Carl, and you've got limited insurance, what happens in a case like that?
Well, two things. One, if you have a cause of action, then the value of your case turns around the seriousness of your injury and the long-term effect of your injury. So let's just say someone is in an accident and there is clear liability. It's the other person's fault, no question about it. And they have extensive injuries and just really high medical bills, and the other party only has minimum limits or $25,000 insurance.
Okay.
Most reputable firms will look at that case and tell the client, you do not need a lawyer.
Okay.
Now, a standard contingent fee contract is a third. If you have to file suit and go through appeals and one thing and another, sometimes that 1/3 is increased. But we have recently seen, and in fact it will be the subject of a lawsuit later, a case where a client went in to see a lawyer. I won't mention any names, but they had some pretty serious injuries. The law firm took the case in, settled the case, never even filed suit, took a 40% fee, $10,000 off the top. It was a knee injury. They sent the person to a chiropractor who customarily doesn't do work on knees. Did not try to negotiate any of the bills that were a result of this situation. Paid everything in full. Now here you've got a closing statement, $25,000 settlement, $10,000 in attorney's fees, clear liability. Go all the way down to the bottom line, net to the client, $1,100.
Oh my God.
The tragedy of that situation is, the real tragedy of it is that the client never saw a lawyer but saw a paralegal and signed a general release, and there was another $25,000 that they allowed to get away.
Okay.
Actually 50.
It was 50, I'm sorry, two UM policies that stack. So they had $75,000 available, but the paralegal settled the case for the 25, gave a general release, and by operation of law, that means the other two policies were gone. They just flew right out the window.
Well, I saw about 10.
I mean, that is a legal malpractice.
And that's 10 red flags.
Right, and what could have happened in that situation is they could have done a limited liability release, which is provided by law, and still closed on the first $25,000. Of course, it was very egregious that the client only got $1,100 out of the 25, but I think the client was told the rest of your money will come from the uninsured motorist part of it, which was another 50, and the general release was signed, and that was the end of it.
And therein lies the problem of, now they would have, they needed a lawyer because of the UM coverage.
Okay.
But, you know, in all fairness, that lawyer should have said, look, you've got a slam dunk. You're going to get the policy limit, both of the liability policy and the UM policy. We will work on some limited percentage basis with you.
Okay.
Now, that's what should have happened.
And we do that every day.
All right.
And most reputable law firms do that.
All right. And to learn more about situations like this, you can log on to reynoldsinjurylaw.com.
Opinions expressed on Law Call are those of the participants and do not necessarily reflect the opinions of 13 WMAZ staff or management, nor any legal or judicial entity. The legal information supplied in this broadcast is general information only and is not intended to be legal advice for any given situation. Do not rely on broadcast information without consulting an attorney. Contingent attorney's fees refers only to those fees charged by the attorneys for legal services. Such fees are not permitted in all types of cases. Court costs and other additional expenses of legal action usually must be paid by the client.